Well, thank you for joining us, and good afternoon. It's my pleasure to welcome you to today to this year's William R. Stewart Memorial Lecture for Labor and Employment Law. Established in 2006, this lecture honors the late Bill Stewart, who was one of our distinguished graduates. A veteran of the United States Army, he earned his JD here in 1959. 40 years later, he was inducted into the school's Academy of Law Alumni Fellows, the highest and most distinguished honor our school can bestow upon one of our graduates. For 34 years, he was a lawyer for the National Labor Relations Board and was the board's first African-American chief counsel. His leadership and commitment to excellence prompted President Bill Clinton to award him the President's Award for Distinguished Federal Civilian Service and to characterize his contributions to the NLRB as unparalleled. At the time, he was the first and only NLRB employee in its entire 69-year history to receive this honor, the highest honor that any civil servant can receive. Past Stewart lecturers have been some of the most prominent labor and employment lawyers in the nation. They include William B. Gould from Stanford University, Laura Cooper from the University of Minnesota, Martin Malin from Chicago Kent College of Law, Matt Finken from the University of Illinois, Sam Bagatros from Michigan Law, Cynthia Estlund for NYU, and Susan Sturm from Columbia Law School most recently. This year, we're very pleased to continue this list of exceptional scholars with Professor Fisk giving this year's Stewart Lecture. At this point, I'm pleased to turn over the virtual podium to Professor Kenneth Dow-Schmidt, Willard and Margaret Carr Professor of Labor and Employment Law here at the law school, to introduce our distinguished speaker. Ken, the floor is yours.
Thanks, Austin. It's my pleasure today to introduce my friend and co-author, Catherine Fisk. She is the Barbara Nachtribe Armstrong Professor of Law at the University of California in Berkeley. She got her JD there at Berkeley, and she got her LLM in legal history at the University of Wisconsin. Prior to going to Berkeley, she has also been a tenured member of the faculties at UC Irvine, Duke, USC, and Loyola of Los Angeles. She's the author of numerous books and articles, 5 books and scores of articles. So among her most recent books are a book, Working Knowledge, Employee Innovation and the Rise of Corporate Intellectual Property, which won 2 book prizes, one from the American Historical Association and one from the American Society of Legal History. The other, of course, is the case book that she writes with me. And I am pleased to say Catherine has written some of the most clever portions of that book. And every year I get to take credit for it with my students because my name's on the spine too. But I've always enjoyed working with Catherine, and she certainly is an interesting scholar who always gives excellent contributions to the work. Today, she's going to address us on the topic of movement lawyers and the taming of social movements. She's going to explore the role of lawyers in progressive movements that advance workers' rights. And she's going to give historical examples like the New Deal and the Civil Rights Campaign of the 1960s. And then she's going to go on to more modern examples such as the Fight for 15 and Red for Ed and Black Lives Matter. And I'm looking forward to it. I'm waiting in anticipation, and I know my class is too. So, Catherine, we're very glad to have you here.
Thank you very much for those generous introductions. I'm truly honored to be giving a lecture in honor of William R. Stewart, who sounds like an extraordinary person and lawyer. And I'm so delighted. I only wish I could be in Bloomington, a place that I've long wanted to visit and never been. So I'm prepared a PowerPoint presentation to go along with my talk. And so I'm going to share my screen and start it now. So as was said, I want to talk about movement lawyers, but the way I was thinking about what lawyers can and cannot do in support of a movement changed, like lots of people's thinking about activism and aggressive lawyering may have changed in January. So let me begin. The fundamental concept of labor unionism and the concept on which labor law is built is solidarity. As the eminent labor and civil rights activist, lawyer, and historian Stoughton Lynd famously put it, more than any other institution in capitalist society, the labor movement is based on communal values. Its central historical experience is solidarity, the banding together of individual workers who are alone too weak to protect themselves. Thus, there has arisen the value expressed by the phrase, an injury to one is an injury to all. To cultivate and to empower solidarity, labor aspired and still aspires to be a movement, that is, an organized, politically engaged, and activist group of people seeking social change. A fundamental obligation of the lawyer as a professional is independence. Thus, although a lawyer owes a duty of loyalty to the client, the lawyer must also exercise independent judgment, as Rule of Professional Conduct 2.1 puts it, and is bound to abide by the client's decisions only concerning the objectives of representation, not the means by which they are pursued. Thus, courts have permitted lawyers to ignore the client's wishes regarding which issues to press on appeal, and even whether to seek to defend a client on the grounds of insanity over the client's strenuous objection. And in this talk and the essay that accompanies it, I wish to explore the tension between solidarity and independence that sometimes looms large for lawyers who are part of social movements. Of course, as Ken mentioned, the labor law has a long experience with this. Most recently, the Fight for 15 campaign, the Red for Ed and Bargaining for the Common Good campaigns of teachers' unions, and of course, other worker and civil rights formations, including Black Lives Matter. I've been particularly inspired by labor and civil rights historical studies of lawyers who worked hard alongside their social movement clients to dismantle the Gilded Age and Jim Crow. For radical labor lawyers in particular, the idea of solidarity between lawyer and client is an article of faith and a core aspect of their professional identity. And so in this essay, I seek to develop a theory of what a lawyer can justifiably do on behalf of clients in the name of solidarity with a movement. In particular, does the concept of solidarity, especially solidarity in the face of legal repression, justify a movement lawyer in using tactics that would otherwise be grounds for legal prosecution, professional discipline, and/or moral condemnation? This is not a straightforward task because movement activism often inspires legal repression, which puts fidelity to client and solidarity and fidelity to law on a collision course. We can see this in many contexts, but if you're wondering what an image of Rudy Giuliani and John Eastman on the stage on January 6th, exhorting the crowd to take action to prevent, as they saw it, the stealing of the presidential election from Donald Trump, it made lots of people think hard about what lawyers can justifiably do in support of their clients. The Capitol insurrection brought the crime of incitement and the crime of sedition back into the news to an extent not seen in many years. And as we know, former President Trump was impeached, although not convicted, for inciting an insurrection. The news since then has reported the FBI's steady work to hunt down and arrest those who participated in the attack on the Capitol building and those who incited it. The January 6th insurrection followed 2 months of litigation attacking the legitimacy of the Biden election victory, and some have called for lawyers to be held to account for enabling the abuses, as they see it, of the Trump administration and Trump's post-election attack on democracy, such as the lawyers who filed about 80 unsuccessful suits after November 8th. It gives me pause that 2 lawyers joined the president on the platform as he rallied the mob, and that many other lawyers filed scores of suits. But it also gives me pause to think about the FBI hunting down people who thought they were engaged in movement activism. I worry about the excessive zeal of the FBI hunting down politically motivated people and groups. And I worry about bar discipline and court sanctions being used to target novel legal theories and the lawyers who make them. I've spent too long reading about the FBI's dogged persecution of labor activists and their lawyers on suspicion of being communists, and too much time poring over the use of the 1940 federal anti-sedition law known as the Smith Act and the 1947 Taft-Hartley Act's provisions that targeted left-wing activism, especially union leaders who refused to swear that they were not communists. So I worry about the use of law to target activism and activist lawyers. And so what I now want to do is explore this tension. I'll begin by talking about the history of solidarity between union lawyers and their clients, and some other examples of lawyer solidarity with causes that many consider to be eminently just, before I complicate the picture. As I mentioned, in 1940, Congress enacted a statute known as the Smith Act that made sedition, along with a bunch of other things, failure of immigrants to register with the government, a crime. Under the Smith Act, the federal government prosecuted a number of union leaders for their sedition. It began in 1941 in Minneapolis when the FBI and US Marshals raided the offices of the Socialist Workers' Party in Minneapolis and St. Paul. Following orders from the United States Department of Justice, they confiscated party files and literature, 2 red flags, and several pictures of Leon Trotsky. The raids led to the arrest of 29 people, including 15 members of the Teamsters Local 544. Eventually, 8 of them were convicted and sentenced, and 18 of them were convicted, and they were sentenced to between 12 and 16 months in federal prison. Among those who were prosecuted and convicted were their lawyer, Albert Goldman. Goldman, along with other lawyers, including from the National American Civil Liberties Union, handled the defense of the 29 accused, along with the appeals. And when the United States Supreme Court rejected the final appeal, Goldman reported for prison along with his clients, and he was disbarred. The government's next major target for Smith Act prosecution were Nazi sympathizers, but that prosecution was eventually dismissed after 7 months of trial featuring constant conflict between the defendants and their lawyers on the one hand, and the judge and the prosecutor on the other. The judge eventually died, allegedly from the stress caused, and following the mistrial, the prosecution ended and the indictment was dismissed. Then, after World War II, the government again prosecuted Communist Party leaders, this time in New York, at the federal courthouse in Foley Square. It was a political trial by any measure. It was long, incredibly acrimonious, featuring constant protests both in the courtroom by the defendants and their lawyers, massive mobilization outside the courthouse. The government spent a great deal of time trying to prove that communism is a bad ideology, including introducing the Communist Manifesto, the Karl Marx work, into evidence, and having witnesses read aloud from the works of Marx, Engels, Lenin, Stalin. The writing on the Smith Act has condemned the lawyers, and here the lawyers are portrayed in a picture from the New York Times, for failing to control their clients and for allowing the trial to be chaotic. The judge presiding over the trial found the lawyers in contempt numerous times, and on the day that the judge sentenced the defendants to prison for sedition, he sentenced their lawyers to prison for contempt of court. After their appeals were exhausted, the lawyers turned themselves in and were sent to prison. And here you can see them in handcuffs. The government was quite harsh toward the lawyers. For example, George Crockett, the African-American lawyer in the picture, an eminent labor lawyer from Detroit, asked not to serve his sentence at a prison in the South because he feared racial violence, but they sent him to prison in Ashland, Kentucky. Richard Gladstein, a labor lawyer from San Francisco, asked to be permitted to serve his sentence in the West so that he could receive visits. The government instead sent him to prison in Arkansas and were quite brutal in getting him there, driving him across country in a long and meandering trip that took 7 weeks, where he was in manacles and leg irons. Of course, there have been other instances of political trials. Recently, Daniel Fardman has written a fantastic article called Resistance Lawyering, in which he looked at the work that abolitionist lawyers did in defending enslaved people who had been captured in the North and were to be returned to slave states under the Fugitive Slave Act. Fardman documents the ways that their lawyers handled the defense, including using every tactic they could think of to delay and to disrupt these prosecutions under the Fugitive Slave Act in order to facilitate the efforts of freedom groups to help the escaped slaves escape from custody and get them on the Underground Railroad to freedom in Canada. And as Fardman points out about what the lawyers did, they were trying to destroy the Fugitive Slave Act from within the court system, just as the Smith Act defendants were trying to destroy the Smith Act from within the court system. There have been other examples of repression of labor lawyers, as I mentioned, that were in part using the leverage of the legal system to silence client activism. As I mentioned, under the Taft-Hartley Act, union leaders were required to swear an affidavit. Here is an image of the affidavit that, as it says, I am not a member of the Communist Party or affiliated with such party. I do not believe in, and I am not a member of, nor do I support any organization that believes in or teaches the overthrow of the United States government by force or by any illegal or unconstitutional methods. These Taft-Hartley affidavits, as they were called, were wildly controversial because they were used to get leftists out of leadership positions in unions. And at the time, leftists were civil rights activists in the unions. This was explicitly about weakening the effort that the CIO was then engaged in to engage in multiracial union organizing, especially in the South. And the penalty for failure to sign a Taft-Hartley affidavit was to deny the union the ability to invoke the protections of labor law. As we can see from these images, the repression of the lawyers and the repression of the leaders, such as here in these images of the Smith Act, prosecution in Foley Square, the defendants themselves are in the upper left, the lawyers are in the lower center, and some of the publicity around this is in the middle, led to a lot of discussion about what obligations lawyers have to aid their clients in resisting unjust laws. Of course, that's happened more recently as well. In 1968, there was a great deal of protest in the streets everywhere, including outside the Democratic National Convention in Chicago. Depending on whose account you believe, there was either a riot of the protesters or a police riot. If you've seen the recent movie on Netflix, it definitely tells the story as a police riot. But it wound up with 8 student activists being arrested and prosecuted. This became known as the trial of the Chicago 8. One of the defendants, a man named Bobby Seale, who is pictured at the lectern giving a speech, didn't know any of the other defendants and wasn't there at the time of the events that occurred. Nevertheless, he was prosecuted as well, as some believe, largely to tie student activism to the militancy of the Black Panther Party, of which Seale was a leader. Seale sought to be represented by his own lawyer, who had handled representation of a number of Black Panther leaders who were being prosecuted all over the place. But his lawyer was ill. And so the judge, Julius Hoffman, went ahead with the trial anyway, simply appointing William Kunstler, who was representing some of the other defendants, to represent him too over his strenuous objection. Seale refused to go along with this and kept trying to speak up during the trial, which prompted the judge to order him bound and gagged, which was shocking by any standard. And here you can see a courtroom sketch artist's rendering of the effort to silence Bobby Seale. Eventually, the prosecution of him was separated from the other defendants. And eventually, their convictions were overturned on appeal, as was the contempt sanctions for their lawyers. So all of these stories that I have told have shaped a lot of people's thinking about lawyer-client solidarity in trials or other legal proceedings that are perceived to be unjust. And they certainly shaped mine, and hence the title of the talk that I originally gave about the taming of social movements wanted to focus on the way in which repression of lawyers was a device to repress disruptive labor movement activism, especially in the 1930s, 40s, and 50s. But as I have said, the events of the last few months have made a number of people think a little bit harder about what we expect of lawyers involved with activism. I want to bracket for the moment the question about whether there is a false equivalence between the activism in support of former President Trump's election and activism on leftist causes. Perhaps both sides would strenuously object to being lumped together, and I don't want to take a position for the moment about whether they're the same or different. I want to use the contrast to illustrate for you why I think we should think hard about how we understand lawyer support of client activism that is borne by solidarity. I read one of the complaints about why what Rudy Giuliani did on behalf of former President Trump was basis for disbarring him in the state of New York. And indeed, there are disciplinary proceedings pending against him now. And in a brief, or a complaint rather, filed by a nonprofit organization with the New York State Bar, urging that Mr. Giuliani be disbarred, here are the charges they make. That the election fraud litigation violated Rule of Professional Conduct 3.1, which prohibits frivolous claims. False statements in press conferences elsewhere violate Rule 4.1, which prohibits knowingly making false statements in other places. The litigation by the state of Texas against the state of Pennsylvania to overturn the Pennsylvania vote is said to be disciplinable because it is a means that has no substantial purpose other than to embarrass or harm a third person. More generally, lawyers should not engage in dishonesty, fraud, deceit, or misrepresentation, and it is said that Mr. Giuliani's statements constitute that. And most generally, and perhaps in my mind most troublingly, the whole Stop the Steal legal campaign is said to violate Rule 8.4F, which prohibits lawyers from engaging in conduct that adversely reflects on their fitness to practice law. These kinds of allegations were made about lawyers handling defense of Smith Act cases as well. So I want to look at, in particular, a case that's much less well known than the Foley Square prosecution that I've talked about, the case against the Hawaii 7, United States versus Fujimoto. Here you can see the 7 Hawaiian activists who were prosecuted under the Smith Act for alleged sedition. They included a school teacher, a staff member for the very activist International Longshore and Warehouse Workers Union, which had just successfully supported the organizing effort of agricultural workers in Hawaii. In the late 1940s, Hawaii was essentially a plantation economy, not a tourist economy. It was controlled by a set of roughly 5 families and family-owned corporations that operated massive sugar and pineapple growing, harvesting, and processing. And one of the defendants was Jack Hall. He is the white man, the only white portrayed in or prosecuted in this case. His picture is in the top center row of the Fujimoto defendants. His name was Jack Hall. The lawyers who handled their defense included Richard Gladstein, who was experienced from the Foley Square trial because he was the longtime counsel for the ILWU. But at a certain point, he had to step away from it because he was in prison for what he'd done in the Foley Square defense. Their local counsel included Harriet Bauslag, who is pictured here in the upper left. She, in connection with her handling of the defense, went with Jack Hall to a union meeting far from the trial in Honolulu to a different one of the Hawaiian Islands to speak to the members of the union about what was going on in the trial. And she said, it's actually not known exactly what she said because the only set of contemporaneous notes of her speech, which were taken by a reporter for the militantly anti-union Honolulu Advertiser newspaper, and he lost his notes, so reconstructed them later at the urging of his supervisor. He said that she said that they were being tried for reading books written before they were born, that the crime of criminal conspiracy is when the government does not have enough evidence. It lumps a number together and says they agreed to do something. Conspiracy means to charge a lot of people for agreeing to do something you have never done. Don't take that as a rule for your criminal law class for you students in the audience. She said there is no such thing as a fair trial in a Smith Act case. All rules of evidence have to be scrapped or the government can't make a case. They just make up the rules as they go along. For the statements that she made at this union meeting, and you can see her giving the speech there, she was disbarred for a year, or her license to practice was suspended. For impugning the integrity of the federal judge presiding over the trial and engaging in conduct that revealed that she was not fit to practice law. Eventually, the United States overturned her discipline in the case In re Sawyer, finding that what she said was no worse than what appellate courts and law reviews say of judges daily. And as Justice Brennan said, dissenting opinions in our reports are apt to make petitioner's speech look like tame stuff indeed. Her discipline was overturned where the lawyers for the Foley Square trials discipline was upheld, in large part because the composition of the Supreme Court had changed by the time her case got there in 1959, as compared to when their discipline cases got there in the early 50s. And I think also because the zeal to prosecute communists was starting to fade by 1959, and the threat of communism no longer seemed to be such a threat. So I want to think about how to reconcile the commitment to the cause with tolerance. And in particular, I want to perhaps challenge something that the great, admirable civil rights lawyer, scholar, Harvard law professor, Dean said in his classic article. He said famously that idealism, though perhaps rarer than greed, is hard to control. And he suggested perhaps more diligent oversight of the lawyer-client relationship by the bench and the bar. What Bell was concerned about was that lawyers would start to pursue their own interests. And in particular, he was concerned about NAACP lawyers who thought that the way to improve educational opportunities and outcomes for African-American students was through desegregation, where some of their clients might have been less interested in desegregation and instead in simple improvement in the quality of predominantly Black schools. And so he flagged, in a sense, the opposite of the problem that I'm thinking about. He flagged excessive lawyer independence, where I'm thinking about excessive, or arguably excessive, lawyer solidarity. But the point I want to question is this issue about how should we think about whether cause lawyers either become too independent or too aligned with their clients. And I'm focusing on too much solidarity. Just to address this problem, I have come up with what I call the activist client lawyer matrix. Now, before I get to the matrix, I just have to point out for the students in the audience that my matrix is not totally original to me. Some of you may have seen on the internet the universal hot crazy matrix. The version on the left attempts to describe how men think of women. The version on the right attempts to describe how women think of men, and you can find them for every possible group on the internet. But with the aid of my 22-year-old daughter, who's the person who introduced me to the universal hot crazy matrix, I came up with the activist client lawyer matrix. The concept is essentially the same. On the vertical axis, we see the degree of injustice of the law under which clients are being prosecuted, let's say, or the moral worth or importance of their cause, going from not that important or not that morally significant to enormously important or significant. And on the horizontal axis, we see a spectrum of behavior that is uncontroversial for lawyers to engage in, that's the green zone, behavior that might be unethical in the lay sense, that is, it's just not the right thing to do, unethical in the sense of violates the rules of professional conduct, destructive, or illegal. And the diagonal line was my first intuition that the more just the client's cause and the higher the stakes, the more the lawyer may be justified in engaging in tactics that might otherwise be unacceptable. As in thinking about the justice of the cause, I think it matters not only that we think about what the clients are trying to do, but I also think solidarity between lawyer and client may be a value all by itself. I come at this from my experience as a union labor lawyer and a longtime admirer of movement activism. I also think we have to come at this from the perspective of it may matter whether the lawyer reasonably believes in the justice of the cause and the importance of doing whatever it is that the lawyer is doing. Sort of trying to bracket, in a sense, the question of what if the lawyer is delusional? On the horizontal axis, as I have said, I think there is a range of ways that we could think about the problematic nature of the lawyer's behavior. And so what I want to think about here is other examples in which lawyers believe that their activism, although transgressing legal bounds under the current law, is nevertheless justifiable. And to do this, I look at two different examples. One, on the left, there is a famous article from the mid-1970s by the eminent legal historian John Philip Reed about the pre-revolutionary lawbreaking by the mob, as they were called, the people who did all kinds of activism, including tarring and feathering British colonial officials, the Boston Tea Party, all that stuff one learns about. And the way in which that's been celebrated in Reed's view, and what I think is interesting about this article, is that he thinks of it not as civil disobedience to law, which is the way that much activism is ordinarily portrayed, but rather as articulating a vision of law, that they had their own law, their rules, it wasn't just natural law, it was a sense about what law properly required. We see a lot of that, of course, in the civil rights movement. And so elsewhere, I have written about a particular civil rights campaign in Northern California, where I live, where civil rights activists were trying to integrate a grocery store in predominantly, well, about a city that was about half Black. The store, as many stores did, would sell to Blacks, but they would not hire Blacks. At the time, California the California voters and the California legislature had both voted down equal employment legislation. This was in the late 1940s. Yes, California was segregated too. And so their efforts to protest segregation led them to engage in some picketing. And as they saw it, their picketing was perfectly lawful. It was speech. And in particular, one of the things that they were protesting was that the white store employees were quite disrespectful, nasty, and in some cases out and out violent toward Black store patrons. Indeed, a store manager had shot a Black customer whom the manager thought was trying to shoplift. And so they decided to picket. The picketing was enjoined. They decided to violate the injunction as a way of creating a civil rights test case. They did. They were arrested, jailed, prosecuted, and their appeal went all the way up to the US Supreme Court, which ruled against them in 1950 in a case called Hughes versus Superior Court, which the Supreme Court handed down on the same day that it upheld the anti-communist oath of the Taft-Hartley Act. In other words, the court treated the lawfulness of civil rights speech exactly as it treated the free speech claims of unions and ruled against them. And I've argued elsewhere that I think it's important to see some of the civil rights protests not as disobedience to law, but rather as a claim about law in itself. I think it's also important to think about the story of lawyers here and the way in which the legal restrictions on what movements could do aimed to use lawyers as a point of leverage to reduce movement activism, knowing that lawyers would counsel their clients to restraint. And I've argued that elsewhere in this paper. But of course, to test my hypotheses about, or my own intuitions about all of this, I want to come back to other kinds of civil disobedience. As you may know, in the late 1980s and early 1990s, and in some places carrying on since, there was a fair amount of civil disobedience to orders, trespass law, all kinds of different kinds of laws, both court orders and other laws, by anti-abortion protesters. Randall Terry, the founder of an organization known as Operation Rescue, explicitly justified the activism by virtue of the high stakes. In other words, the anti-abortion protesters' vision of the legality of what they were doing was very high on the vertical axis in my framework. And so what I want to think about is what all of this adds up to for lawyers who represent unions when the law is extremely unfavorable. and then I'll wrap up and open it up to questions. Today, we see an organizing campaign among Amazon warehouse workers. Currently, there is union voting going on in Bessemer, Alabama, where Amazon built a big warehouse recently. And Amazon has been fighting this unionization campaign with everything it's got, barraging the workers with anti-union messages, up to 5 text messages a day to their workers, daily mandatory meetings where the managers talk about how terrible unions are, prohibiting, of course, the unions from talking to the workers on the job site, which they can do. So the organizers then tried to speak to workers on the public roads as they were coming to or going from the warehouse, as you can see from this picture here. And Amazon then went to the leaders of the city and got them to change the timing on the stoplights in order that cars don't stop when they are entering or exiting the warehouse. Amazon, of course, claims that this is to improve traffic flow. The union believes it is to prevent the workers from speaking to each other about unionization, even on public property. The other example I want to think about is a very famous labor strike from 30 years ago that happened in Appalachia and then spread all over, where United Mine Workers members went on strike against Pittston because, as they saw it, Pittston was abrogating its longstanding obligations to provide health benefits for retired miners, job security, and other things that the union had long fought for. They went on strike. Pittston hired replacement workers. The workers started protesting en masse, and then everybody in the community started protesting. Pittston then hired security guards to prevent the protests. Protesters were violent towards the security guards were violent toward the protesters. It went on and on and on. And ultimately, there were solidarity strikes involving 40,000 miners in 10 states. One of the lawyers who represented the United Mine Workers at the time did an oral history with me, and I asked this person about what it was like to be a lawyer for the union at the time. It was obviously incredibly difficult. As the lawyer pointed out, we were up to 4,000 arrests. The union had been held in contempt so many times for so many injunctions, and the protests continued anyway, so they were fined, so that the fines against the union far exceeded any money that the union had. Ultimately, it was settled for $10 million, which was just a tiny fraction of what the union had been fined for. And the lawyer talks about taking a certified check for $10 million, which was a very significant amount of money for the United Mine Workers, on a train up to the Pittston headquarters in New York to hand it over the company. And the point that was raised is that this was perceived as a legal system that was terribly unjust to the workers, and they wound up paying a huge price for their protest, which puts the lawyers in a very difficult situation. They had to do things like go into jails and counsel some of the 4,000 arrested people about how to safely engage in a hunger strike that they had announced they were going to engage in, for fear that these people who didn't know how to conduct a hunger strike would accidentally kill themselves. It went on and on and on. And so what I want to suggest, and then open it up to questions, is that a lawyer confronting unjust law faces tremendous difficulty. I think that's true for lawyers for the Stop the Steal campaign, or true for Operation Rescue, true for lawyers doing all kinds of different things, and true for union lawyers. And ultimately, the best I can say about what lawyers should do is bear in mind the matrix that, yes, there are some causes that are worth fighting for, including by engaging in illegal activity. And so my test for myself is, if I were representing a Jewish client in the late 1930s, would I forge documents in order to help them escape? Would I forge documents in order to help them get their property transferred to somebody where the Nazis wouldn't take it? I would do it in a heartbeat, because to me, that's what the pursuit of justice is. But I have to be careful in saying that, because I think maybe Randall Terry thinks the exact same thing about violence to prevent abortions. And that's a challenging system for any lawyer to practice in. Thank you.
Thank you so much, Catherine. That lecture has given me so much to think about. My name's Deborah Whitus. I'm also on the faculty at IU Maurer, where I teach employment discrimination law. And first, I have been asked to just, the screen flashed and it's in the chat, but any of you who are seeking CLE credit, the code is 03621, which you need to email to lawcle@indiana.edu. And I also want to go ahead and invite the audience to begin putting questions into the Q&A for me to pose to Professor Fisk. But share with you that in the course of your lecture, many of our audience members pointed out that Harriet Buslag is actually an IU grad. If you were here in Bloomington, we could bring you down and show you her picture, which is on our walls here. And so it was, one, I was impressed by how many of my colleagues were on it immediately. But it was particularly meaningful when you were telling that story to all of us here in the IU Maurer community. And I'll go ahead and start with a question of my own, while other questions hopefully begin appearing. And I really appreciated you're sort of bracketing the question of false equivalencies, or whether or not various equivalencies are false. I mean, I think that's obviously a very salient question in a lot of people's minds right now, and particularly juxtaposition of the insurrection in response with the Black Lives Matters protests and what makes those similar or dissimilar. And then I was thinking about that as you introduced the matrix, and the sort of question of the justice of the legal the legal cause, because I think that often part of the challenge is that there's opposing legal principles at stake in a lot of these cases, and both sides will think that they are very highly important. So with the abortion example, you have on the one hand, as you highlighted, is this murder? We should be treating it as murder. And you have on the other hand, many people would be just as firmly convicted, no, this is fundamental to women's equality, to autonomy, to personal choices. And that's also super important. And so whichever side the law comes down on, it's almost acceptable to challenge it on that scale. With the civil rights movement, yes, you know, addressing discrimination. On the other side, you had business owners saying this is freedom of contract, this is personal liberty, the government, you know, we have a government of limited powers. And again, fundamentally important values at stake there. And so I guess I wanted to hear you talk a little bit more about what factors one can look to try to distinguish between those, when it seems like they're, at least for movement believers, will be fundamentally important issues often on both sides of these debates.
It is an excellent question. And first, as to Buslag, I knew she was an IU graduate, and shame on me for not remembering that at the moment. So thank you. Bravo IU for educating women at a time that few, you know, so many law schools wouldn't admit women. So in the end, I think there is always going to be a value choice about what we put on the vertical axis. There is no way to get around value choices when we decide that something is sufficiently important to justify tolerating more illegal or disruptive lawyer conduct. And given that inevitably there is going to be a value choice, I'm not sure we can ever expect agreement among people about exactly what goes on the vertical axis. And typically, the more disruptive behavior is, the more, in political trials, for example, the more it's because those who are engaged in what appears to be repression to those who are disrupting think that there is some value that justifies repression of, to save America from communism, or to save unborn lives, if that's the way you think about it, or to, to save the Aryan race from the Jewish horde, as the Nazis in Europe thought about it. All I can think about to help resolve the conflict is that in a democratic society, some degree of tolerance for competing viewpoints has to be part of the equation. Now, tolerance is not something that everybody necessarily shares. There are a lot of people who don't believe that tolerance for different viewpoints is a value or even a high value. And I don't have an external to the system argument in favor of tolerance other than to say, like it or not, we live in a fairly diverse culture, and including in this highly polarized time, I have my views about Donald Trump and his lawyers, but so do other people. So in the end, I'm just not sure there is the perfect solution to that.
Thank you. And I would have been happy if you could have given me the perfect solution, but I am not surprised that that was challenging. There is a question now, which is, do you have thoughts as to why the lawyers in particular seem to have been targeted for sanction in these kinds of cases? So for example, in the Giuliani example, ordinarily we think the greatest punishment from Rule 11 is to dismiss the case, but really this was more about targeting the lawyer instead. So any thoughts you have on that piece of your story?
I think, and I can't comment on why target the lawyers now, because I haven't done the research, but I think lawyers were targeted under the Smith Act, under the trial of the Chicago 7 or 8, because they were perceived as being especially destabilizing to the government, because they challenged the legitimacy of what the government was doing. And sort of what makes a trial a political trial in part is when the defendants will say, if it's a criminal prosecution, will say, I'm being prosecuted for my beliefs, not really for any other criminal activity or any conventionally criminal activity. And once those are the terms on which the lawyers are speaking, that threatens the legitimacy of the prosecution. It calls into doubt the neutrality of the judge, the legitimacy of the court, the motives of the prosecution, which in turn tends to prompt them to go after the lawyers really hard. So I think it reflects both the bar's sense that our value choices are supposed to be different, better neutral, which I just don't believe. And also the sense that when lawyers start joining clients, it is uniquely threatening to whoever it is that's trying to suppress this form of activism.
Thank you. So I noticed that we are actually already past 1 o'clock. The last question that I had, which just lets you know that people are planning to keep thinking about this, is whether the PowerPoint slides will be made available. And I think if you're comfortable with that, we can work with Chelsea to do that.
Sure, happy
All
to.
right.
And there will be an essay published in the Indiana Law Journal, I believe, so where I lay out this in much greater detail.
Wonderful. Well, let me just thank you on behalf of all my colleagues. This has been really a wonderful, wonderful hour spent thinking about these questions.
Thank you.